Virginia's cannabis laws are often described as legal but not really. In 2025, that confusion hasn't gone away, in fact, it's grown. Today, we're breaking down exactly what Virginia residents need to know about cannabis law in 2025, what has changed, what hasn't, and why misunderstandings can still carry real legal consequences. Why this video exists. Cannabis policy in Virginia sits in a unique legal position. Personal possession was decriminalized and partially legalized, but a fully regulated adult use market still does not exist. This gap between legalization and regulation has created uncertainty for residents, businesses, landlords, local governments, and even law enforcement, particularly here in Norfolk and the Hampton Roads region. This video is strictly educational. No promotion. No advocacy. No lifestyle framing. Just a clear explanation of what the law actually says in 2025. Is cannabis legal in Virginia in 2025? As of 2025, adult possession of small amounts of cannabis remains legal under Virginia law, but that legality is limited and conditional. Virginia allows personal possession within legal quantity limits, home cultivation under strict rules, state-regulated medical cannabis access. However, commercial sales for adult use are still not operational statewide. There is no licensed retail market for recreational cannabis. This distinction is critical because many legal risks come not from possession, but from how cannabis is obtained. Section 2, Medical Cannabis versus Adult Possession. Virginia maintains a separate medical cannabis framework overseen by the state. Medical cannabis patients must be registered. Access products only through state-authorized dispensaries. Are subject to specific compliance requirements. Medical access is regulated. Adult use possession exists without a legal retail system. This dual system often leads to confusion, especially for residents who assume legalization means retail availability. Section 3, Home Cultivation Rules, and Common Mistakes. Virginia law permits limited home cultivation, but the rules are strict. Requirements include plant limits per household, secure, private growing areas, no public visibility, no sales or transfers. Violations related to cultivation often arise not from intent, but from non-compliance, especially visibility, location, or quantity issues. Local enforcement can vary, which is why understanding municipal interpretation matters. Section 4, Local Enforcement and Zoning Reality. Cannabis enforcement is not applied uniformly across Virginia. Local governments, including cities like Norfolk, retain authority over zoning interpretations, business restrictions, nuisance enforcement, property and lease compliance. What may appear tolerated in one jurisdiction may trigger enforcement in another. This is where residents and property owners often underestimate risk. Section 5, Employment, Housing, and Civil Impacts. Cannabis legality does not override private policies. In 2025, employers may still enforce workplace drug policies. Landlords may restrict activity through leases. Federal housing rules still apply. Cannabis law intersects with employment, housing, and insurance more often than criminal law, and these consequences are rarely discussed. Section 6, Why this still matters in 2025. The absence of a regulated adult use market keeps residents in a legally vulnerable gray area. Misunderstanding the law can lead to civil penalties, lease violations, employment termination, local enforcement actions. Education is the difference between compliance and exposure. What to watch next? In upcoming videos, we'll examine why Virginia's retail market remains stalled, the difference between decriminalization and legalization, how local zoning shapes cannabis enforcement. If you want deeper breakdowns, case explanations, and local discussion, those happen off YouTube inside the community. Please like, comment, and subscribe for more videos like this.